It is said that a lawyer's knowledge is his stock in trade. And on this note, I welcome you all on this discussion on electronic records under the newly enacted Bhartiya Sakshya Adhiniyam. Today for this discussion, I have Advocate Prateek Gupta, Advocate Pallavi Bhardwaj and Advocate Saurabh Bhartiya, who shall be joining us in a bit. So sir, we are living in a very digitalized world where everything is available at the click of a button. Now sir, we come across cases that are related to either cyber crimes or digital frauds, or you talk about distress calls. So sir, in such situations, there are certain electronic records that need to be scrutinized and evidence has to be appreciated accordingly. So sir, how far do you think that the BSA has dealt with the admissibility of such evidences, such electronic records under its very new enactment?
So, the BSA, 63, section 63 is basically recasting of 65A and 65B of the Indian Evidence Act.
Yes.
And Indian Evidence Act, that amendment was introduced in 2000,
Right.
whereby 65A and 65B were introduced into the Evidence Act, which was based on the 1968 law of England, almost verbatim copied. But that law of England was repealed somewhere 20 years down the line in about 1980s or 1990s, but we continued with that.
Right.
Now there's a judgment which is a landmark and the most exhaustive judgment by the Apex Court in 2020, Arjun Rao, 2027 volume 1, volume 7, SEC page 1, which deals exhaustively with 65B and 65A. And it reiterates the consistent view of 2014, which says that if when is a certification under 65B subsection 4 required? So for example, if a person has recorded a video on a particular device and that device is tendered into evidence, then the requirement of 65B subsection 4 certificate may not be required because that's the original device that has been given. But if that video is forwarded and used elsewhere, then the requirement of a certification for that evidence to be admissible would be required. Now, but that judgment also, it's a concurrent judgment by 3 judges. Justice Ram Subramanian's judgment is a supplementary view which elaborately details on foreign jurisprudence, on Canadian law, on the British law, and also the American law, which is the Federal Record of Evidence,
Yes.
which is their Evidence Act basically. And they've given out a chart in that judgment as to the manner in which different materials can be used to prove in evidence. So if, for example, there's something on WhatsApp or on Facebook or on Instagram, the method of proving that is also prescribed. So it's all reproduced in that judgment, and I think maybe we would probably have to, with changing times, keep up with that pace and probably incorporate those practices also in our jurisprudence, because cybercrime and digital footprint is what is necessary to track while cracking a case or even conducting a trial. Using that device as evidence is one part, but to ensure its authenticity and to ensure that it is not tampered, that is another aspect, and dimensions are changing. You see now banking frauds or identity theft, artificial intelligence I think is also one of the topics which is a major concern, and I am not sure as to how efficient our law enforcement agencies or even us as society are to tackle with the there are obviously plus sides of artificial intelligence, but it's a serious threat also on some occasions. Somebody can just forge or impersonate someone's video and orchestrate a crime, and that person without proof could land in the dock. So there needs to be some mechanism, although yes, this act does take care of the aspects of authenticity and transparency in maintaining the sterility of that evidence. But it's an evolutionary process. Technology is changing really rapidly. जो 10 साल में पहले change होता था, I think it's happening in 10 months or maybe less than a year. So the law enforcement agencies and also the government and society at large must really keep up pace.
Yes. So recently I just came across the situation where some celebrities had complained about a lot of deepfakes of theirs coming in public domain. So that is something that, like you said, that society at large, they need to address things like this. So I believe that insofar as incorporating digital evidences in BSA was concerned, I think it goes hand in hand with the BNS as well, which we shall be discussing in our subsequent sessions as well. But rightly pointed out that there are AI deepfakes that are circulating, and again, there's no such thing that goes like you can literally root down that where is the cause of such thing happening. So in that situation, it really becomes difficult to analyze whether what is the authenticity of such evidences which is to be tendered thereafter in the trial. So ma'am, my question to you is that insofar as the admissibility as discussed by sir is concerned, how far do you think that expert testimony is dependent upon the admissibility?
So first of all, the expert testimony that is given under section 45 of the Indian Evidence Act 1872, and now it has been shifted to another section. So there are also the grounds given on the basis of which expert has to give the evidence. So why do we need to have expert testimony? That is, the court, they have to adjudicate and they have to give a judgment based on the reason. Sometimes there are facts that are not within the knowledge of the law, and the court also, the judge also needs the evidence. They also need some common or the special knowledge over the subject matter. We call it as expertise, be it in the manner of handwriting, art, skill, fingerprint, and there are many other branches. So that is known as expert testimony, wherein expert is called into the court of law to testimony to clarify that whether this handwriting belongs to this person or not, whether these fingerprints are of the person at the crime scene or not. So we need that expert testimony. It is just to facilitate the court to reach an adjudication. It is not binding over the judge to have that evidence in their hand and to act over it. It is just an opinion given by the expert. So what is a shadow area here? For example, if we practice in the district courts in Chandigarh, so we have a common person who will refer whenever there is a matter with regard to where you have to check the handwriting of the person. You are going to call the same person, he is going to come give the testimony that whether this handwriting belongs to that person or not. There are very few people who will refer to forensic lab or who will go for that techniques. They are not going for the advanced techniques. They are referring to very basic level that are easily accessible. So in that case, expert testimony becomes weak. It is already weak evidence because it is not a substantive piece of evidence. It has to be corroborated with another evidence in order to give it a very strong evidentiary value, and that also depends upon the decision of the judge sitting, that whether he wants to imply that expert testimony, whether he wants to use it or not. Firstly, this was all about the expert testimony. Now there is another section that refers to the grounds. It was section 45 of the Indian Evidence Act. In the new act, it is 57, I believe. In that, you have to give the grounds on which the expert was giving the evidence or he was giving the testimony that this belongs to this person. For example, there is a case in which you find the poison in person. Maybe it's a suicide case or maybe it's a murder case, you are not sure, and you found the traces of poison within the body of the person. So in that case, the relevancy of the expert testimony comes into fact because it can help you to lead into a circumstantial evidence later on stage. So this is all about the expert testimony.
Right, ma'am. So sir, so far as the primary and secondary evidences are there, so how far do you think that BSA has discussed all of those when it comes to electronic records, essentially?
So, evidence besides electronic earlier was that it has to be led in the affirmative in the primary form, and there are section 65 I think was with respect to leading secondary evidence, and there are criteria laid down and conditions laid down where the court can allow lead of secondary evidence. With respect to digital evidence under 65A, 65B, now I'm referring to the Indian Evidence Act because the judgments are in the context of the Evidence Act, but those provisions are pari materia somewhat. Slight differences, slight improvements in the BSA now, but largely the jurisprudence remains around in the Indian Evidence Act. So 65A and 65B were introduced, and there was a certain view before 2020 and between 2014 and 2020, between the time that the judgment in PV Anwar was given and Arjun Rao's judgment was given. There were two judgments, which was one was Shafi Mohammed versus State of Himachal, and there was another one of 2014, wherein a divergent view was taken that even if a 65B certificate is not there, the courts can rely on the provisions of 65 to prove and take into account the secondary evidence, which subsequently in 2020 and earlier in 2014 the Supreme Court said that no, 65A and 65B are a complete core in itself, and that is why this is a special provision with respect to electronic evidence. So insofar as electronic evidence is concerned, if there is a copy made from an original electronic device, there has to be a certification by a person who was using that or who was competent to use that device. The definition, the word used is a relevant person, has knowledge and belief that that device was used regularly over a period of time, that alleged occurrence or that offence has been committed, and so therefore he has to give that certification, and only with that certification can that piece of evidence be considered admissible. Otherwise it would not be admissible. So therefore now the question is that the investigating agencies need to be kept abreast.
Yes, sir.
You know, if you don't take a certification under 65B, that vital piece of evidence could be lost. And you know, you generally tender an evidence today, the judgment may come 6 years down the line, and there would be no turning back at that stage. So the benefit would obviously, you lose evidence and you lose a trial in that situation. So it's very important to maintain that record of the devices that are used, and that person using that device must certify that this printout was taken from this computer, and this computer has been used for a period of time, and that person must be a person who has been using that computer, you know, so as to verify the source of that evidence in the form of that computer. So this is all defined under the Act. It's a very exhaustive definition of what a computer system is, and a network of computer systems, and what is the output of that computer, and that has to be certified in terms of 65B subsection 4.
So, like you said that evidence can be tendered directly from a computer device. So, sir, does the law state that it has to be mandatorily cloned into some other computer, or it is subjective to the facts of the case?
There may be a situation, there is an occurrence, for example, there may be an occurrence happening. I recorded on my phone.
Yes.
If I go and give my witness in court with my phone, that is original, that is primary. But if that video goes viral, I choose not to go forward, not to come forward in court, and somebody else, once that video has gone viral, goes into court and says, I received this video. So that would be secondary evidence insofar as that device would be concerned, but that person would have to say that I received this on my phone, and this is my phone that I was using. I received it on this application or whatever, and then give a certification that this was being used by me in the normal course, and this has been with me, and the implications of giving a certification under 65B4 would then come into play.
Right.
Because that's not the original device where that video was made.
And sir, insofar as this is concerned, how far do you think that chain of custody becomes relevant? Because I read a judgment which states that if during investigation the chain of custody is not complete, so in that case the benefit of doubt arises towards the accused.
Right.
So how do you think BSA would be able to do justice to that, because it is very complex?
You see, that's a larger infrastructural problem that you're asking, because you need software backups, you need data protection, you need identity protection, and you need the police stations or the investigating agencies to be equipped with the infrastructure where they can keep that data in probably a server or in some secure cloud or a device which would be free from tampering or hacking. There have been instances where they've kept a device, they've kept some data in some server, and once they go to the court, play that CD, the CD turns out to be blank.
Yes, sir.
So where does that evidence go, and whether that evidence was stored in a cloud or in a secure server which is free from hacking, which is protected from hacking? That is a larger infrastructural problem which probably the state would need to address.
Right. Ma'am, I have a question for you, that when we talk about digital records and when we talk about the admissibility of evidences, so ma'am, we've had this conversation about AI and how does that come into picture. Do you think that AI could be helpful when we talk about addressing these minor issues, be it investigation or be it admissibility? So could you shed some light on that?
Yes, definitely. I believe the new law, that is the Bhartiya Sakshya Adhiniyam, BSA, as we are referring to, it has been changed with in light of the changing technology, science, in the light of advancement in the science and technology. For example, now the entire digital and the electronic record that has been made primary evidence under section 57 of the BSA. So initially we used to have this primary and digital evidence. We had to, in order to make it admissible, we have to bring it under the category of secondary evidence by way of section 65B of the Indian Evidence Act. So whenever we had to, make a video from a phone call, we have to annex it to the evidence. So we had to make it a secondary evidence first. So firstly, this provision has been done away. Now the entire evidence, be it in the phone originally, so that can be used as a primary evidence under section 57. So now there is another interesting quality that has been introduced in the new law. We have two performers under part A and part B of the BSA, wherein initially the mechanism of admitting digital evidence by way of section 65B. So the entire person, for example, let's understand it with some hypothetical situation. If a person, he is having a record of the electronic, say, call recordings and everything, you are going to that person and the authorized person is going to make a certificate which you are going to take it before the honorable court, and then it is going to be admissible. Because without that evidence, without that certificate, that evidence is not reliable because of the landmark judgments. We are coming to that in the next point. So now we have a standard performer setup and we have part A and part B for the same in the BSA. So now we need not to have, every person cannot apply his mind and write an application to make this evidence admissible by way of a certificate. Now you have a standard performer, you just have to fill it and the evidence is recorded on record. So this is the number 2 quality that is making the digital and electronic record very easy to be admissible in the era of artificial intelligence. Thirdly, how to verify that whether this recording is credible or not. For example, whether it is morphed or not. So there is also technique that has been mentioned. You have to record the hash value of the video when it was started and when it was ended. So the entire hash value that has to be recorded and filled in that certificate on the spot when you are making that, when you are trying to annex that evidence in the court of law, and that hash value that stays same entirely. So imagine if in the initial time the hash value was different and while during the arguments you find a difference between the same, so it can depict that yes, it has been morphed or it has been changed or modified. So this is the third aspect which by way of using technology we are also ensuring that we have to have a fair trial and we also are adhering to the principles of natural justice.
My question is to Ms. Marcos. There are two terminologies that have been introduced in BSA, that is electronic record and digital record. Now the issue is that what is the difference between both of them and which particular record is to be used for which particular experts analysis is required.
Okay. So yes, there is a difference between digital record and electronic record. First of all, both of these terms have not been defined. They are given under definition clause section 2 clause 1e in terms of evidence. So we have oral evidence and we have documentary evidence. In that we cover the electronic and the digital record, but there is a difference between these two. For electronic record you need to have a certificate, for digital record you need not to have. For example, when we get deliveries from Amazon or Myntra, we give our electronic signature. When we fill any form for the competitive exam, we give our signature. That is electronic record. And in digital record, there has to be a certifying authority. There has to be encrypted version also that has to be seen. and details of these are given under the Information Technology Act 2000. It was given beforehand, but in the Indian Evidence Act there was an amendment in 2000 by way of which the term electronic record and digital record was mentioned. Earlier there was only one terminology used. So now there has been recently a case in 2005. It has been just filed in the Supreme Court. It was present in the live law. The name of it is Vinod Kumar versus something, I am forgetting the name. So in that judgment they have challenged now that there is a loophole in the BSA wherein under section 61, 62 and 63, wherein in one section we are using the term digital record and electronic record, they both are used as primary evidence. But coming to section 62 and 63, when we are talking about the certificate, we are only referring to the electronic record. So why this discrepancy? Secondly, there was an order passed on 20th January by the Advocate General of Haryana to all the ADs, and it was issued by the Haryana government, wherein they have stopped the e-vetting of the replies. For example, whenever the ADs, they have to file the record in the Honorable High Court, they go to the AG office for the vetting of the responses. This is a procedural mechanism. During the COVID era, it was done online. So they were sending an email and they were vetting the response reply, and the final one was submitted in the court of law. But now by way of 20th January, so they have passed an order that it is for the better communication and effectiveness that the person should come to the AG office. They should have a discussion so that then they may file the order in the court of law. So now my question here comes that we are moving forward towards digital era, and we are going forward for saying video conferencing, online hearing, online appearance, everything. But now we are not relying for the e-vetting of the responses. Why? That is to enable to have a communication, better communication, and then to discuss the reply and then to file it. So this is also this is also a grey line wherein we can say that there are certain cases, important cases, in which a person needs to have a personal communication. So digital record or the electronic record, they are different for the court of law. In order to have an evidence admissible in the court of law, we need to rely over the rules as laid down by the Bhartiya Sakshya Adhiniyam. But wherever technicalities are involved, wherever the procedure is involved, we can have another way also. That is also possible.
Sir, I do have a question. Nowadays, large number of evidences are coming through social media, Facebook, Instagram, whatever. Sometimes what happens is there are posts which are later on deleted. What is the authenticity of that deleted post, or AI is also involved in those cases? What is the BSA? BSA have to do?
That's again a very grey area, because if a post is deleted, for example, from Facebook, then the investigating agency would have to probably touch base with Facebook and get it out of their server.
Yeah.
Because everything that is deleted is kept intact on their servers. So that's a larger issue of retrieval of deleted posts. But yes, if somebody's taken a screenshot of that deleted post before it was deleted, that could be tendered into evidence from that original device. And if that original device is not there, it could be shared to someone or taken a printout, then that certification under 65B4 would again come. And these are larger, infrastructural issues, because WhatsApp chats are encrypted. Now you have disappearing messages. A chat with someone could disappear after it is done. So, and there are other applications also. Telegram is more encrypted, and I believe there are other applications also. So these were meant to be used for the public for their conveniences, but sometimes it has a reverse effect also. Some undesired elements could use it. Signal app, I think, is one which is used by a lot of clandestine operations. Terrorists being using it, underworld and criminals using it. So because it goes below the radar. The issue there would be again ineffective policing in tracking those apps. But then again, there's a grey area of a fine line of how much to police. You can't. I mean, the devices that we are using now. This is the only device. This is the only way in which police is able to crack all crimes. Because whenever an occurrence is happening in some area, the active phone numbers of that area are picked up by the police, and it's a digital footprint that is retraced by the investigating agencies to take out from one phone number to another and then devices. So it's a larger, from traditional crimes of bodily injuries happening, it's going on to a different dimension altogether.
To add on, I would like to suggest that we also have the another laws, for example the IT Act, the Digital Data Protection Rules and Act as well. So wherein we have covered now OTT platforms. So we are not limited to BSA, no doubt the change has been made. So we have been given a possibility wherein now the digital record, which was initially very difficult to prove, now it has been made the primary evidence. So now by way of another enactments, we can also make use of them to authenticate our evidence or to make it more credible in the court of law.
My further question would be, these additional authentication, like for these kind of reported crimes, do we need any additional authentications by the forensic reports or by the experts that we...
See, if you have money, you can go for it. If you have resources, you can go for the expert evidence, you can go for the forensic study. Like we have watched CID and they were referring to a forensic lab. They were having a forensic lab. We do not find it like now. We refer to it in government cases and we have CFSL in Chandigarh. So wherein we refer to it in very serious crimes. We are not using it in very basic or everyday routine manner because the process is cumbersome. But yes, the facilities are there and it is over the person who wants to use it. So there is also, just like CFL, there is another, I am missing the name, there is another body in Chandigarh only, so under the Companies Act. So if you want to find the name of the fraudulent company, you may go to their office and there is a fee and they give you a time limit and they have a software where you can put the names of the director, and where in case the directors have, they have become proclaimed offenders or they have run away. So you can find and locate their exact position or where they are right now. So there are facilities, I think we are not aware of the same. Yes.
So my question to you is, since you've been in practice for such a long time, so should the lawyers rely on court-appointed experts for their analysis, or should they hire private experts from their own pocket, because they might not be the outcome of the court-appointed experts might not be favorable?
But you see, the bottom line in evidence, any evidence or any expert that is produced in court is its credibility and its impeccability in integrity. Right? So it can be a private expert or a government expert. There are, in the earlier times there was a particular handwriting expert who was much used across North India, Punjab, Haryana, for handwriting experts, and his reports were highly credible. So the courts would believe those reports because of the reputation that person had for giving authentic reports. So it all boils down to that individual expert and his credibility and his integrity in giving that report, because this is what is important. For the truth to prevail, the truth must be elicited and thrashed out. There are views that the party, there are judgments that a handwriting expert produced by a party will always depose in favor of that party. So therefore that is only a reference, so to say, because it has to be corroborated by other evidence. But in terms of institutional integrity, for example, a ballistic report from, why would they refer to, you will often hear about CFSL, FSL Madhuban or, FSL reports in Chandigarh or Mohali, because these are institutes of highest integrity. And the reports from these institutes, these are government institutes, would be more acceptable by the courts because of their integrity and authenticity, yes, and the credentials.
So sir, as far as I could understand, that there is no set parameter as to according to which we could decipher that whether this particular expert is credible or no. So sir, in that case, how far do you think that the courts have to be very cautious in examining such kind of witnesses, even if it is...
That's where the process of trial comes in, that that particular expert is called as a witness and he is put to extensive cross-examination so that the truth comes out and the issues are effectively culled out from his report. That's how the process of trial is, where issues are framed and whatever the bone of contention is, the dispute between the parties is, if it's a civil dispute or a criminal trial, then what is the point to be proved? Then that particular witness who is deposing for or against that point is summoned and put to extensive cross-examination. That's where effective advocacy was and effective trial work was.
So sir, does the burden of proof also shift in that case?
Burden and onus to prove as per 101, 102 section of the Indian Evidence Act keeps shifting. The onus to prove a particular fact will always remain on that person, but once he's discharged that initial burden, it would shift. So that would again case-to-case basis. But in a criminal trial specifically, it's always on the prosecution first to prove the case, and then a slight chink in the armor would also give that benefit to the accused. So for the defense in a criminal trial, they only have to introduce that little bit of doubt in the prosecution version to get things in their favor.
So sir, these are the certain things that could be included in the BSA, but still the Act is silent about it.
I think it's all the trial process. The trial process essentially remains the same. Just the procedure has changed. The method of tendering evidence and the method of the legal jurisprudence on the admissibility of a digital evidence or electronic evidence, that has changed, but the process of trial remains the same. So again, investigation and then proper trial, proper advocacy at the trial level is what is the hallmark of a successful adjudication in that case.
Sir, can over-reliance on experts weaken the judicial discretion that is?
I don't think so, but it all depends on how overboard that particular expert goes, and then how would a particular court interpret that evidence, that report by that particular expert.
But that is the question, sir. What happens is that from prosecution point of view, they hire a government appointed expert. His testimony would be different to the expert that the defense lawyer has hired for his own expert evidence. If they don't meet each other,
there would always be some commonality, because if an occurrence has happened, there would be at least some common strand in what has happened. For example, if there's an injury case, if the defense says that he had fallen, a particular person had fallen off a bridge, for example, and the injuries are in the nature of a fall, but the other side says that no, he was beaten up, thrown, and then beaten up and then thrown off the bridge, the injuries would reflect something else. So there is the medical jurisprudence on that. Modi's book on medical jurisprudence is since a very long time, and the most credible book commentary on medical jurisprudence. So there would be obviously a certain strand of the truth in that, and that has to be elicited by the courts or by the lawyers also in the process of the trial.
Sir, my question is that what are the other legal remedies that a person would have in case the expert testimony comes out to be false in the later stage, of course, once the accused is convicted? So what all other legal remedies?
There are other, it could be an eyewitness account. In circumstantial evidences, you could have other witnesses to prove those circumstances. So technology along with circumstantial evidence with corroborative value is what the courts always say that is to be used for arriving at a decision. But then again, the party tendering that evidence or leading that evidence would have to be a little careful on what evidence has to be led and to what extent can it be used.
So usually in POCSO cases, I've usually seen that it's the doctor's testimony always which is relied upon than any other thing. So I think there the accused will be inside always, because the doctors always say that the possibility of sexual assault cannot be ruled out.
That's right, because the enactment is such where even a statement by the prosecutrix is enough to land a conviction. You don't need any other evidence. So that is a particular enactment in which probably then again the onus is more heavy on the defense to conduct cross-examination of the prosecutrix or the complainant or the witnesses, and then get their own witnesses to puncture holes into the prosecution version. So that's again a process of trial, but this particular enactment also is framed in such a way that this is how the setup has been made.
So why can't court appoint the expert rather than giving party the discretion of appointing an expert?
You see, courts do, local commissioners are appointed. In the CPC Audit 26, I think, is where local commissioners are appointed, and those local commissioner reports are really useful at times to arrive at a conclusion. And the law on local commissioner reports is also that the reports, there is no remedy of an appeal or a revision against the order of a local commissioner. So that's where it ends. Once a report is given, that can be considered by the court, and an independent local commissioner appointed.
Ma'am, don't you think that courts are now more flexible along the electronic records than the old route requiring the rigid certification for electoral certificate?
Yes, definitely, because at the end of the day, expert testimony or all the electronic or digital evidence or record is just an opinion. It is not binding over the judge or over the court. So the end decision has to be made by the judge only. So this is a very important factor that we cannot miss. So the entire thing has been done just to, so that we can pace up with the digital revolution that is taking place, so that our legal system is not lagged behind. It depends upon the legal acumen and the awareness of the lawyer who is bringing evidence in such a form that it is authenticated, it is so much credible that on the prima facie, on looking at it, you cannot deny the authenticity of the same. What will happen? It will facilitate the judge to pass an easy judgment because the record available is legally well sorted or very well, annexed in the records. So it is a very good practice if it is done in the subordinate courts. So that in the later on stages, when the case goes for appeals or for other procedure, so that the element of changing the judgment, that is very less until and unless there is a question of law involved. So for that matter, it is a tool that has to be used. But yes, the courts of law, they are more flexible also because they are aware about the legal provisions and the digital revolution that is taking place. So they are very proactive, especially the judges in High Court, in our Punjab and Haryana High Court. They are very good at using Chat GPT that was used in a trial case, in a trial matter over a bail jurisprudence. So they know how to use it. So it's not wrong to take bail jurisprudence answer from Chat GPT, but at the end of the day, the application of the mind is only of the person who is sitting over the dice. That person is the embodiment of the wisdom. That is why he is known as the judge, and whatever the judgment he has passed, that has to be revered.
Now, adding on to the question that she asked, now the divergent view which Sir pointed out, that there is a divergent view of the Supreme Court which says that 65B certificate can be given at any stage. Rather than the Supreme Court again in a larger bench ruling came upon heavily that no, it is important that 65B affidavit is given while the time the electronic record is being given. Now, as during the discussion you have pointed out that there is a chain which can be established, there is a blockchain technology that we can go into, then I believe that this particular provision of 65B is just merely a procedural tactic in order to go back and catch somebody if it was a flawed evidence. Even if the 65B affidavit was not given at a stage when the evidence was taken into consideration, I believe that the divergent view which was earlier taken by the Supreme Court, which stated that it could be given at any stage, since the doctrine and the maxim that procedure is the handmaiden of justice, should come into picture rather than the current view which is prevailing. That's my opinion. I would like you to shed some light on it, that why that particular divergent view is wrong or the current view should.
You see, that divergent view came in Shafi Mohammad's case, And the reasoning given was that for the lack of evidence for a person who would want to produce certain evidence, he may not have the means to get that evidence. So therefore you cannot burden him with that certification process and lose crucial evidence. So in the 2020 judgment, this reasoning was found to be flawed because CRPC at that time under section 91 and 165 also had inherent safeguards where the court could also ask for a person to come and produce, for example, the 65B certificate. So that reasoning was said to be flawed. But this divergent view came between 2015 and 2018 in two judgments. The earlier view of PV Anwar was in 2014. That was reiterated in 2020 and also in 2023. So before that, in 2005, in the Parliament Attack case, Navjot Sandhu's judgment, the benefit was given to some extent where the 65B certificate was not there on the call records. That part was also read down in PV Anwar in 2014. Right, that 65B certification is a must. So these are reasonings, and the jurisprudence is always evolving. Maybe 5 years down the line, this jurisprudence, early jurisprudence may come back again. So that's under 141, 142. The law of the land is what is declared by the Supreme Court.
So as we all are aware, we are on the topic of primary and secondary evidence, and we have with us joining Advocate Bhartiya, who has just joined us. And sir, could you please shed some light on how primary and secondary evidences, so far as the electronic records are concerned, and how they are dealt with in the BSA?
Yes. So first of all, the term electronic record has itself not been defined in the BSA, which itself is a big loophole that the legislature has left behind. Even the journal clauses that would not come to rescue there, because at that point of time nobody has thought that electronic record could have been incorporated. So coming to the facts of the case, as everybody is aware that evidence can be of two types, primary or secondary. Section 57 of BSA is about primary evidence, that the original document itself is produced. For example, the recording device is itself produced before the trial court, that is primary evidence. Now section 58 deals with the term of secondary evidence, and section 60 deals at when secondary evidence can be read. So secondary evidence can be read if the original is in the possession of the other person that whom you were trying to fight the case against. So if he has, let us suppose, a CCTV footage that he has, which has somehow, but he is in possession of that DRR, you have to first send him a notice, and that notice is under section, if I'm not wrong, and then 63 or 64, and then you have to send him a notice, and then you can produce the document against him, and then 64 is the notice. And secondary evidence can also be allowed once it is destroyed or lost. And secondary evidence, now what is secondary, the scope of secondary evidence in BSA has been enlarged. So example, a recording device, if it's broadcasting something as well as a recording, it both becomes primary as well as secondary also. So secondary evidence, you can just give a certificate from a person that it is not tampered, that it is not altered. Now electronic record, because it is more susceptible to get tampered and altered with. That is why the certificate's importance has been enshrined, which was earlier 65B, has now again been incorporated at 63. So now this certificate itself is a doubt as to who can give this certificate. There are judgments to that effect by the Honorable Apex Court that who is competent. The landmark judgment would be Anwar P versus PK Bashir. So even the BSA has failed right now also to tell us who is competent to give that certificate. Can it be a person who is in possession of that device, or does it have to be a technical person? So this is a confusion which again would be dealt with constitutional courts itself, and maybe Anwar P and PK Bashir's judgment might come to the rescue there, but still the legislative should have widened the scope once BSA is only and only being the only under the other two, CRPC and the IPC revocation. BSA was the need of the hour. Other two might not have been, but BSA was the need of the hour. But the legislation again has failed to provide, first of all, the definition of electronic record, and then again to who is the competent person to give that certificate. Now again, there is a judgment by our High Court, that is Gurmain Singh in 2018. It deals as to how secondary evidence is to be led. So interestingly, neither our High Court rules and orders, neither the Indian Evidence Act then, and neither BSA now has given the procedure for such. So Justice Khetrapal has interpreted that you do not even need to give an application. This is a misconception with many trial court advocates who give an application to lead secondary evidence, and sometimes it gets dismissed. It is not such. It says that section 66, as it was earlier, and High Court rules and orders are totally silent that you need to give an application. All it says is that you need to give a notice. That notice, you can prove that secondary evidence has to be exhibited. Its veracity would be dealt at the later stage. So even BSA has now again failed to state so whether we need to move a formal application to lead a secondary evidence, or whether we can just tender a secondary evidence and its veracity would be seen at the time of final arguments. So if I can conclude that legislation still has left everything to the constitutional courts again to give us clarity as to how this electronic record is again to be led into evidence in primary as well as secondary. Primary is simple, but secondary becomes a bit tough because you are trying to portray a copy of an original document. And electronic documents being more susceptible to alteration, and with the invent of AI, it is very tough for the courts to see whether it is a genuine evidence that is being led, and that is why it is so important to say that who is to give that certificate. Can a layman give a certificate about the authenticity of a document or not? That is, the legislation is still silent about it.
To add on to the sir's view, I might have divergent view here. So after PV Anwar Bashir judgment, so we had the judgment of Shafi Muhammad, and then finally we are settling the law with the Arjun Rao Pandit versus Kushan Rao judgment, that is 2019 or 2020 also you may refer to it. So in that judgment they have categorically mentioned, Supreme Court has said that we need a certificate, it is mandatory under section 65B clause 4 of the Indian Evidence Act, and presently under the BSA it is also very important because they have given the pro forma of how the certificate has to be made. Initially every person using his discretion of mind, so whoever the competent authority was. So for example, if you are going to a computer operator, so we have to see who was the examiner or the certifying authority at that point of time as per the provisions of the Information Technology Act 2000. So he will give you the certificate who is having the control of the computer or the other system. In that case, initially it was very discretionary, so as whoever is going for that record, that person is writing an application and he is getting it signed and then presenting it before the honorable court. Presently under the BSA Act, we have a pro forma given under part A and part B where a clear certificate has been shown. You just need to have the copy, you have to file along with the hash values of the recorded evidence, and then you can file it in the court of law. It has made it easier for the judge to pass the judgment because you are having a standardized document that has to be filed. And secondly, with regard to the digital and electronic evidence, we have made it a primary evidence under section 57 of the Indian Evidence Act. That is a big transformation because initially in order to prove electronic record, you have to bring it under the category of secondary evidence. But now you need not do that because it is clearly a primary evidence in the advent of the technology and artificial intelligence. So that's a really effective move for all of us to understand.
So my question, if I may be asked to the honorable panel. So since 2003, as everyone is aware, the judgment came in Praful B. Desai. State of Maharashtra was a Praful B. Desai, allowing witnesses to tender their evidence, chief examination in chief, and the cross-examination through video conferencing since 2003. Where at that time we didn't have that much of infrastructure for video conferencing itself, and in subsequent judgments also of honorable high courts and the Supreme Court, time and again they have allowed this. Now, in today's time, We are living in a generation where AI is rapidly increasing. Technology AI is increasing rapidly, and AI has been so much effective that it can change the whole scenario of a live broadcasting video as well. Now, in such cases, as per the legislature, the BSA itself, there is no categorically mentioned that what guidelines are to be seen, as Musa has said, that there is nothing on record that who is the person to identify the electronic record, to authenticate that record. So how can it be possible to tender the evidence such, and in my opinion, it might hamper the whole trial itself.
Exactly.
Okay, so I would like to answer it in a part, and rest I would like sir to answer it. So Punjab government, so there is a e-portal, so whenever the police officer, they have to make an investigation, even under the Bhartiya Nagrik Suraksha Sanhita. So we have the provision while recording, since electronic evidence is now admissible. So we have to record the FIR whenever e-FIR is also available. During the time of investigation, the police officer has to make a video, and that has to be submitted in the court of law. Now we can also doubt the credibility of the video, like maybe the police officer started it late, so this was a problem faced by many police officers, because there is a time limit also. Like for few minutes you can record, after that the portal closes. You have to make the another video. But to that respect, there is a hash value that has to be recorded at the time of starting the video and at the time when the video ends. And that value will remain same. It's basically a hash value that is a term used by the computer analyst, or maybe
the value that determines whether something is interfered with or no.
Yes. So that is a very much credible source. Because whenever you are giving it to the court of law, you are putting the hash value. And if there is any change at the starting and the ending, that clearly shows that it has been tempered or modified. So this is a very, I think, innovative technique to be used. It was there since time and again. It is not that we have evolved it suddenly, but now we have become more aware about it. Yes.
So yes, even our Punjab and High Court rules and orders, they've given a very detailed I would say procedure to record video, how to record video evidence. If you're abroad, you have to go to a consulate journal, you have to get yourself identified by a competent authority and then log in through their computer for the video recording. Once you file compromise quashing, we have seen that certain directions are given to record statements through DC. That is done through the consulate journal itself. So you're not allowed to participate in that through your own personal devices or your other mediums, like WhatsApp video recording is not allowed, Skype, Zoom, that are not allowed, and the software by the NIC is to be uploaded on that computers also, and similar is here also. Even if some video evidence is to be recorded, even if you are in India, then also you have to go to your nearest Ilaka magistrate and you have to avail their facility for video conferencing, and then only your evidence will be recorded. And as my friend has already stated, that those hash reports would always identify whether it has been tampered or interfered with. And coming back to the form that we were earlier discussing, so if it is my view that the entire legislation purpose should be to simplify the code for every layman. So let me read that certificate, which any layman, let us assume from rural India, would never even we as lawyers would not be able to understand how to get it.
Even I have this one.
I state that the hash values of the electronic digital record is obtained through the following algorithm: SHA1, SHA256, MD5 or other. Anybody would raise their hands as to what these mean? So this has to be defined by the BSA. This has to be defined by the legislation. Who is competent? Am I just to fill this, or am I to understand this form? So this has to be by an expert. They have to define it. A layman person from a rural cannot, even we as lawyers, educated lawyers, nobody knows these values. So this is just a mere formality. The legislation has to step up.
and provide easier legislation and codes for everybody to understand, rather than making it only complicated for the layman to understand the common law.
So for our viewers and for those who are attending, let me tell you, this was a similar doubt that that was raised in my mind when I had a look at the Evidence Act and when we were talking about the certificate. So this SHA 256 and the subsequent boxes, check boxes that are there, these MD5 and SHAI. So these are the various national Institute of Standards and Technologies recommended guidelines. So which determine that these are the only things that Indian law rely upon. So that is why these are here in this. So this is only for educational purpose and not dissecting from the view that sir is
This is my view, that a law should be in a simplified manner for everybody. If they want an electronic record to be tendered, they should just say that so and so person is competent to give this certificate. He can see anybody who even before, I think about 2-3 months ago, when this BSA had come in, I never knew what are hash reports and what are hash values. I think that would be the case for everyone here. So a layman person or from a person from a rural rustic area, it is impossible for him to state with absolute surety that these are the hash reports that he is availed. Or is it just a mere formality for the court? If that is a mere formality, I think that should be struck down.
Even the form has to be countersigned.
Yes.
Who's to countersign it?
Nobody says.
Nobody, nothing.
Form B is part B is to be by an expert.
Yes. But who's
Part
that
A,
expert?
the part expert can be so that expert can be defined by.
If we go with, in Karnataka, they appointed these experts. Who were those experts? It was police personnel.
Exactly.
How can a police personnel certify that this record is authentic one?
And I'm
So
very
they
sure
were appointing them, but you need an expert who can derive the value, the hash value.
Exactly. So yes,
It's something which is big lacuna.
it's a big lacuna, and the legislation has just introduced a mere formality, which and once it is just a very technical formality, which is mandatory, then every layman person should be first educated about this, or at least their definition should have been incorporated, but nothing has been done.
My question is, as we see that AI is affecting the whole life of everybody in the country, so we think that the legislation is aware that it is going to affect, but how much is to be affected? So there is a wait and watch policy by the government that they have left these things undefined at this stage. Maybe they are going to do wait and watch.
That should not be the case with government. They should not be wait and watch. They should be 3 steps ahead of the criminals. So if you leave lacunas, then cybercrime is to increase.
But sir, there is a report by Niti Aayog over the artificial intelligence in India. So they have extensively laid down the rules, and for that matter, India was also way ahead when they incorporated the Digital Data Protection Act on the lines of the European law. So I think it is not always the legislature who are leaving the lacuna intentionally. There are hash values, no doubt, but how can you ask a doctor to, simplify the name of the disease, which is in Latin or which is in Greek? So we have, for example, we have the Latin maxims, and we have so much of things that cannot be changed for the convenience of the layman, because that makes our profession different. Now similarly, these are the terms that are to be understood by the computer analyst, and there is where expert testimony comes into picture. A person who is expert, he has the skill, he has studied computer in detail, so he can give you the value. Your job as a lawyer is to go to him and you can, fill the form with his aid, not to offense anybody.
Part A is not to be signed by an expert.
Yes,
Part A is to be signed by a person. That can be a witness,
yes,
or can be a layman. So once Part A is to be signed by a layman, then those values they don't understand this. So you are encouraging, what you are encouraging is perjuring. Because without fully understanding the contents of an affidavit going into you tendering it, that encourages perjury.
Sir, I don't think so, because you are just entering the hash value as
without
per
fully
the line.
understanding it. So if you go by any affidavit, It says that I verified to the true contents of this affidavit. Nothing is concealed herein, nothing is being suppressed from this court. And similar is, but without fully understanding this, the BSA the legislation expects us to tender a certificate without fully understanding the contents of it, which exposes a person to perjury in future.
No, they want the advocate of that particular person to be trained.
Yes,
In that.
exactly.
But advocate is not advocate cannot be even a witness, advocate cannot even tender this.
When deriving the hash value, that person will be having an advocate, so that advocate has to be trained to derive the hash value.
But there are so many judgments that an advocate cannot neither be a witness to a case, can neither be a witness, cannot countersign any documents.
Yes, that is one thing, but that you have to derive the value. That derivation cannot be.
So eventually, if what you're saying is correct, then we are also open for bar council proceedings if it becomes false, because we are also not fully understanding the
The
contents of it.
derivation has to be on a certain formula which you have to apply.
It
And
has
that
to-
derivation on certain formula would come it would be the same for the same file. And if there is another copy of it, it
Let
would
us
change.
assume we want to tender a pen drive, right, which is a secondary evidence.
But what I have made out from
From the
BSA is
origin,
that they
from the
want
primary, we
advocate
want to tender
derive.
a pen drive. Right, from the primary DRR, we want to tender a pen drive. So, a person who has taken that pen drive, he is to give that certificate as per my interpretation, right? Who has procured it from the main computer, he is to give it.
Saurabhji, when we draft a petition is being drafted by whom?
By us,
On the instructions of
on the instruction of the client.
because right, and the affidavit is tendered saying that whatever is there in the petition
Nothing is concealed.
and it is my version.
Yes.
This is how it is.
But this is what I am saying, that also affidavits normally.
I guess this is the parallel that is there.
This is-
but the only problem is that how an advocate is to be trained for to
But
do the right
my
thing.
problem is that these formalities should be by an expert, and expert should be defined as to who is this computer expert. That should be defined. A layman cannot be expected to fill out this form. If he is filling out this form, he is not fully understanding it and tendering in courts. And if you are just saying that tendering a document, I think it's a pious document. Every document or exhibit is pious and best to your
If
knowledge.
we see the form, there has to be a place for hash value in the upper part, the A,
Yes.
and in the B. The expert is corroborating that
from
the
which
hash value that has been derived is the same that is there, and he has checked it.
Just let
But
me
the
read,
problem
just
is the
let me
expert
read
who
this
is the
part.
expert.
Just let me read you two parts from the formula. The digital device or the digital record source was under the lawful control for regularly creating, storing or processing information for the purpose of carrying out regular activities, and during this period the computer or the communication device were working properly and the relevant information was regularly fed into the computer during the ordinary course of business. If the computer digital device at any point of time was not working properly or out of operation, then it has not affected the electronic digital record or its accuracy. The digital device or the source of the digital record is owned, maintained or managed, operated by me. Then this person is to give. Let us assume he is a rustic person. How is he to understand everything that is written there? And if you are letting it for the advocate to interpret.
This is the part A, to be filled by the party.
Yes.
The party has to take the advice of whom?
Let us assume.
And
So what you are
partly
saying
by
is,
expert.
so what you are saying is, the Honorable Apex Court has given victims to fight the case on their own without engaging lawyers. Let us assume this is the scenario, and the person is doing this, and the person is doing this. Then who is to give him this support?
Then the person, the party has to do it. Or
So the
My point
so justice should only be for the educated and the elite.
No.
That is what you are saying. That is what the BSA and the
So there
legislation
is
is saying.
also a difference. You don't need to have a certificate for digital record. You only need to have certificate for electronic record, and that is always by the certifying authority.
But the difference has not been given in the BSA. It has neither defined
You want
digital
to
record,
go to
it has
the
neither
idea.
defined
There
electronic
is a
record.
new petition that has been filed in Honorable Supreme Court in 2025 by the name of Vinod Kumar. So they are also stating that yes, this lacuna exists wherever. So in one provision they have mentioned digital and electronic recorder primary evidence. But in the next two sections, they have only mentioned the mechanism of certifying the electronic record. So yes, there is a lacuna left behind.
So that is what was the hurry? They could have indulged in the only hurry that I could see was the pending elections was the only hurry to give
Sir, on
us
this
this.
note, actually, people have been saying that instead of Indianizing these criminal laws, it is more or less a tribute to Lord Macaulay who actually made it. Because it's
See,
not
the only point that I agree was CRPC and IPC should not have been revoked. Maybe Indian Evidence Act was old enough and should have been revoked, but with a better BSA. That is all I'm saying. With a better
but BSA is almost like it's 95% same as it is.
95% is same, but 10 to 5-7% they've added.
That would have been amended.
That should have been amended, or you want to revoke it, but with a better act. But with a better act. So what I am stating is, with everybody, not to offend anybody, but the BSA, it seems, is only for the elite and educated. It is not for the rustic and the poor. It is not simplifying. The intent of legislation should be that everybody, the poorest of the poor and the most uneducated person should have access to justice. This should be the intent of every legislation, which BSA has not.
I think we can all agree with you. So
should have made the procedure much easier, rather
should have made the procedure
more robustic.
And they are encouraging perjury because we are tendering into certain documents not fully understanding the context.
So now there are two conflicting sections also. If you have read section 62, special provisions as to evidence relating to electronic record. Now they say that contents of electronic records may be provided in accordance with the provisions of section 63.
Section 63.
Now 63 says notwithstanding anything contained in the Adhiniyam. Now when the word notwithstanding is used, it is an overriding power.
It is an overriding.
Now what is the sense of introducing 62? I am not able to understand. Now they are saying that 63 is not important also, and the other way than 63 they are saying it is important.
The way I interpret is that 62, that if you want to lead, then you may do it by the end of 63. That is what, if you were intending to lead, this is what, but this should have been a simple line, not a full section.
May be proved. The word may is there, that is quite confusing.
That causes confusion, but what they've done is that cut, copy, paste. 65A is now in 62. No mind has been applied into making this BSA.
Because once you write notwithstanding, it overrules each and every section there in the act. And now they are saying that no, it may be provided.
Because
it is an option.
The earlier 65A, which is now 62. So earlier 65B, which is now 63. So they never thought to change it also, because that was the starting of that section. It was that if you want to lead it, take the 8 of 65B, and once you want to take the 65B has an override effect that it can only be proved by fulfilling these certain conditions.
Yes, that is there. Now just one more thing, if I may point it, I'm sorry, I'm taking this time. So I have a doubt. So now in section 57, there are 4 explanations. Explanation 4 to explanation 7 for electronic evidence and digital record. Now in explanation 5, they say that where an electronic or digital record is produced from proper custody, such electronic and digital record is primary evidence. Now I am not able to interpret thoroughly what is the proper custody word you defined it. Now I'll just add on something. Now the explanation 6 says where a video recording is simultaneously stored in electronic form and transmitted or broadcasted or transferred to another. Each of the stored recording is primary evidence.
Yes.
Now as per my knowledge, if we take secondary evidence section 58 into account, secondary evidence is copy of your original.
I'll just tell you what. So something is being broadcast in your TV and you are recording it via your phone. That is secondary evidence. But what is being broadcasted on the TV, it's been simultaneously recorded to a disc or DRR or whatever DVD, then that is primary. But if you're recording it through your phone, that itself LED or from whatever TV or from whatever broadcasting device you're recording, that is secondary. That becomes secondary.
That's it. That's
Keeping it short, I think we must conclude now.
Yes.
I think it's
So, yes. Yeah. So as we come to the end of this incredible event, I would like to take a moment to thank you all who have come here, and I would also like to acknowledge the efforts which every member has put in to make this event an incredible a successful one. I would also like to extend my heartfelt gratitude to the esteemed members, Advocate Prateek Gupta, Advocate Saurabh Bhartiya and Ms. Pallavi Bharadwaj, JRF Punjab University. I hope that this present discussion was an enriching experience for all of you, and you would use these takeaways in your journey of advocacy. I would also like to tell you that this was one of the first sessions which are already scheduled for 17th and 19th, so I would request everyone to grace those occasions as well. And once again, thank you everyone to join us here and adorning this event with your presence. Thank you all.
Thank you so much.